Essex Police Constable Charlie Thompson is to appear at Basildon Crown Court tomorrow, the 11th of August, after being charged with assault by beating. Thompson is said to have assaulted a man after stopping him for suspected drink driving on the A127 near the Mayflower Business Park in Basildon on the 19th of January. After the incident, Essex Police are said to have made a mandatory referral to the IOPC. Now that's important because on the police conduct website, which is part of the gov.uk website, it says that death or serious injury cases are mandatory referrals of incidents where no one has complained and no recordable conduct matters have been identified, but where the circumstances of the incident need to be looked into. Death or serious injury. So Thompson must have given his victim a pretty good pasting then. The IOPC started their investigation in February this year and in June passed their file on to the CPS for consideration of charges. The CPS authorised charges contrary to Section 39 of the Criminal Justice Act 1988, which doesn't necessarily correspond with the fact that they had to make a mandatory referral to the IOPC. An Essex Police spokesman said, "We are aware of an incident involving an Essex Police officer which took place in Basildon on Wednesday, January the 19th. Once we were made aware of the incident, the officer was placed on restricted duties and a mandatory referral was made to the IOPC. The IOPC made the decision to independently investigate the incident. Essex Police continues to fully cooperate with the IOPC investigation and now awaits the outcome of legal proceedings." Section 39 of that Act relates to common assault and battery and says common assault and battery shall be summary offences and a person guilty of either of them shall be liable to a fine not exceeding level 5 on the standard scale, to imprisonment for a term not exceeding 6 months, or to both. But let's not, while we're here, forget about the legislation on doing exactly the same to a copper, which says subsection 1 is subject to section 1 of the Assaults on Emergency Workers Offences Act 2018, which makes provision for increased sentencing powers for offences of common assault and battery committed against an emergency service worker, an emergency worker acting the exercise of functions as such a worker. Now, if you ask me, police who assault somebody should be dealt with more harshly than if it's a member of the public on another member of the public, considering they should obviously know better, but this is the world we're living in right now, when police can rape, murder and assault people and get lighter punishments than if it were you or I. Nice to know the equality under the law rule still exists. But just flipping back to section 39, it's a common assault. A common assault is a summary offence. Why would the IOPC need to independently investigate from a mandatory referral? A mandatory referral, as I've said, relates to death or serious injury to a person. Why would that need to happen if it was just a common assault? Common assault, obviously, could be the fear of immediate violence, not actually touching somebody. Although this is assault by beating, so he obviously did put his hands on the person, but it's a summary offence. So I don't get why the IOPC are looking into a mandatory referral, which is saved for death or serious injury, over a common assault. Doesn't make sense. I think the police are not telling us something.